Hi everyone, and welcome to another episode of North Alabama Law Review presented by Johnston, Weston. I'm your host, Shauna Hill, and today we have joining us Mr. Christopher Weston and Mr. Bennett Driggers. Hello guys.
Hello again.
Hello.
So today we're going to be talking about another topic of non-competes and intellectual property. We find these a lot when we go into employment is where we see them the most at, and we really don't think about them on the front end because they really come into play at the end if anything goes wrong, such as the end of your employment. So guys, when you want to dive in first and kind of give our viewers a rundown on the types of agreements and what they entail exactly.
It's all you, Bennett.
All right.
I was going to make a joke. So
No. Yeah, a lot of times when you enter an employment agreement, there'll be a non-compete clause in those agreements. And what that's based, typically the employer is trying to protect you from getting their customer list and other information and going out, quitting their employment and going out and trying to use that information to compete directly against them. Non-compete clauses are not very well liked by the courts. There are some qualifications to what I'm saying, but essentially there has to be a reasonable time and a reasonable area. Courts in Alabama don't want people to not be able to make a living at what they're good at. So essentially, if you're working as a salesperson with one company and you have signed this agreement, it's going to limit the scope and distance, of the area you would be able to work in after that in the same field competing with that former company you were with. And this would include even if you're a independent contractor, they can have you sign one of those agreements. But the overall point is they're meant to restrict you from using information you've gained, like customer list and product pricing and everything, to go out and directly compete against this business who had this information and you had access to it during your employment or during your independent contract agreement, from hurting their business essentially. I mean, it's not, but again, the courts limit the ability to enforce those based on time and distance because there again, you don't want to keep somebody from being able to provide for their family in an area of in their career field. So that's kind of an overview of that, but Chris, you have anything to add?
yeah, so, and this is going to sound funny. I'm going to go over a little portion of this, is that, so in the last episode we talked about non-disparagement agreements and we talked about non-disclosure agreements. So non-competes are saying that because you have information from either a circumstance, a previous employer, a project you were on, or somewhere you went just to either purchase something a lot of times, especially, if it's factory made or specific, bespoke, as they say in the suit industry, that now because you've seen that stuff, you can't even practice that same profession or engage in business in that same area just because you have that information. So this is a stronger version, is what I'm going to call it for practical purposes, of an NDA, of a non-disclosure agreement. It's, you have this information, so now we don't even want you engaging in this area of business in this area for a couple years. So the way I explain it to people is the difference between, being in a relationship or a marriage and not speaking badly about somebody or not using what you know about someone in that marriage, versus being told, okay, you can't date anybody for 2 years after divorce. Okay, and that's kind of where the funny part is, because people don't really conceptualize this as well as they should. They understand the language, they understand the restrictions. But what they don't seem to understand is that it is literally nearly identical to not speaking badly about your former spouse versus literally not being permitted to date anybody for a couple years after your divorce. Okay, that's kind of the way I equate it to people when I'm explaining it. You know, again, this is again in the business context, in the purchase context, in the project context, or the, you know, invention context. So it's, you know, obviously not family law, but it is important to understand is that it is limiting you from even being engaging in your profession for a period of time in a certain area. And that's where the real limiters are, is that where the courts come in and step in and stop something is they will say, you know, even if it's broad, because this is the biggest issue that we see with these, they're too broad. They'll say, you just cannot engage as a bricklayer in this area. And they'll give like a region. Or they'll give, you know, they'll make it nationally, or say anywhere, period, for 5 years, 6 years, 8 years, 10 years, indefinitely, just depending on what it is. And realistically speaking, where the courts have limited these is to reasonability, as in time, in place, and in action. Okay? So let's say you are a bricklayer and you sign an agreement that you're not going to compete with bricklaying company once you cease being a master bricklayer for that bricklaying company. If it was that broad, generally speaking, the courts would not permit that kind of non-compete. But they might enforce it for your county or your state, or, you know, within 150 miles. You know, courts usually will interpret these to say within a couple 100 miles is reasonable, within a county is reasonable, direct competition is reasonable, for a period of roughly 18 months to 2 years, okay? And regardless of what's in the agreement, be aware, for you business owners at home, just because it's too broad doesn't mean that the courts won't enforce it in general. The courts have the authority via case law to restructure those to where they are deemed reasonable. It's not an all or nothing. And again, that's where litigation really gets opened up if your terms are not specific, is that you can press one of these that on its face is not enforceable, and the courts have the right to change that terminology in most instances to make it enforceable, to limit it to where it is enforceable based on the intent of the parties, okay? And so again, this is one where if your language is not very specific, you can really walk into legitimate long-term litigation.
It sounds like the courts, when they look at non-competes, they really look at the whole picture, like you said, such as what does your region look like? What is it saying you can't do a job at all, or just not a competition? So giving the courts look at that, I'm assuming they would look at the population of the area. So something a more metro area, is that going to have a less stipulation than, let's just say, a small town where everyone knows everyone? If you're done with that job, it's such a small area, non-populated area, that your competition is, you know, only one other person. It seems like that would be a more constrained non-compete than a big metro area.
Can I jump on this one?
Yeah.
Sorry about that, Bennett. A lot of times we'll see the inverse, actually.
Wow.
Believe it or not, a lot of times we will see the inverse because there's a lot more customers. There's a lot more, you know, what's called goodwill in a company, especially in a larger area. And so when you step into something, if you don't have a pre-existing client base of your own, or that if you have a very limited one, what we have found is that they'll walk in, and then when they leave because they do good work, what ends up happening is that a lot of those clients may want to stay with them. Mm-hmm. And again, in a larger, more metro area, there can be a lot more damage to a business for bringing someone in, getting them, you know, getting their feet under them, and then that person leaving. Whereas in a small town where everybody knows everybody, it's like, well, look, they're going to choose between one of the two of you, right? And so if they don't like you, that's because they don't like you. That's not because this man learned something from you. And so actually a lot of times we'll see them more enforced in metro areas. Also, and I've got to say this, it really depends on your judge or jury, because it comes down to interpretation. I have seen it and have had major litigation where they will look at something and decide because someone got a value or because of the nature of the relationship, it will either not be enforced or limited or be a problem. And I've seen it also vice versa. So it really comes down to who your finder of fact is, very much so. And so, like I said, ambiguity is not your friend in that situation. Bennett?
Well, one of the things we run into nowadays is exactly where are you doing business, especially if you have an internet-based company.
Oh, yeah. Oh, man.
That's a whole nother level of non-compete agreement, and we'll get into this later in the show, intellectual property rights and things like that. But that's just it. Believe it or not, this is still not a highly litigated area with the internet, but it's getting that way because more and more people are doing the same thing on the internet. And okay, where did they get this from? They used to work for me. I had a non-compete. What do we do? Well, they're selling in California and in Japan and in Korea and in Canada, and so where are the limits to that? And trust me, I don't have all the answers to that bigger picture like that today, but there's a lot to consider on these non-competes, especially if you're in an internet-based business. I think the courts, and I'm assuming here, don't ever assume, by the way, in the law, but I'm assuming the courts will address it the same way. What practices and customer information did you take with you to try and start your competing business against your former employer or the person you were contracted with as an independent contractor? So they're going to look at all the facts and make that decision, but it's a lot bigger than it used to be. We're not talking about Alabama businesses and just people within certain counties in Alabama. We're talking about the World Wide Web. So where does it end?
Yeah, I've seen a lot of that. I'm sorry, I didn't interrupt. Excuse me.
Just depending on the type of business you're in and where you operate that business from, and there's a lot to consider. So get a legal team involved, especially if you're already being sued for it. But just to review stuff again, we spoke about this on the last show. It's less expensive to hire an attorney to review things and to give you your legal standing ahead of time before you sign some kind of agreement than it is for them to try to get you out of that agreement or to protect you when you're being sued over that agreement. So it's very important to get with an attorney or a legal team ahead of time to protect your rights before you enter into something that's going to keep you from making a living in your chosen profession for who knows how long, depending on the extent of the non-compete.
Yeah, and that's something I would like to jump in on that one, especially with the internet-based businesses, is, it's not just about your terms. I mean, that is the most important thing, but it's also doing an appropriate risk assessment before you bring someone else on and share your process or the way that you do business. Because again, when there is uncertainty in the law like there is here, like, when you're dealing with overlapping spheres of customers or bases or, groundwork or whatever it happens to be, like, let's say you're, engaged in a business like an internet business where, okay, you leave a company, you move 600 miles away. Normally, if you were, doing a business that was hands-on, that'd be more than far enough. But if you're engaged in an internet business of any form and you engage customers that may or work for another company that overlaps, and so it may only be 100-mile overlap, where it's like, your radius is, 500 miles, and your other, the business that you left, their radius is 300 miles, and you have a 100-mile, overlap of customers. You can have a major problem there because that's 100 customers. That's a lot of money in some businesses. And so, and if you are a business yourself and you're thinking about bringing someone on, when there's ambiguity in the law of how that would be enforced with new technology, you can really run into risk, and being able to do an appropriate risk assessment of how something would be enforceable can be very, very important. because again, depending on how far away they move, how far away, ex-employees, engage in your business, well, you have their physical location, their company's physical location, your physical location, and then where your customers do business or where your customers are purchasing things, and getting down to the intent of the parties, what customer lists, what processes, how those overlap can lead to a great deal of litigation. And so having some internal structure limitations on what you have them involved in and the way that you're internally organized can be a way around that where a non-compete may not be enough.
Well, let's look at it this way. There are a lot of hybrid businesses now that do both. They have brick and mortar locations and they sell over the internet. So there's a lot of things there, a lot of risk in entering into any business. It's I won't say funny or amusing, but it's interesting to watch somebody come in with this great business idea and talk to us about it and want to set up a business and things like that. Because one, we can talk to them about risk aversion up front before they start that thing. Before they enter, into any kind of contracts with anybody, we can help up front. We can also come out to a brick and mortar location and evaluate your risk there. And there's a lot more risk than just these contracts that we're talking about in a business. So we're willing to do all that for you to make sure before you enter into these agreements, before you sign a lease for your new business, to make sure you have the right entity style set up. I know we're getting off course a little bit here, but when we talk about risk, just creating an LLC and starting a business out of your garage has a ton of risk. So talk to an attorney ahead of time, and we're willing to sit down with you and cover those risks, tell you things you can do in your business. I've been in business for my entire adult life and know the risk of things involved in those businesses and different types of businesses, especially in brick and mortar locations. There's practices and things you can set up ahead of time to protect your business. If you're in business, at some point you're going to have a lawsuit filed against you. It may not be anything you've done wrong, but it's better to have systems and practices in place that will protect you and that you will be prepared to defend that lawsuit when it does happen. I won't say if it happens, when it does. If you're in business long enough, it's going to happen. So keep that in mind. These non-competes are just part of that. So if you need a risk assessment for your business, come see us.
Yeah, and I know we got to get to some questions, but jumping right off of that, you saying that made me realize we're not telling you that there's all these pitfalls and to be totally risk averse. And we talk about the risk so much, and so it sounds like we're saying don't make a step without an attorney. And I'm not saying you were saying that, Bennett. I'm just saying even when I talk about these, I talk about all the pitfalls, all the risks, all the different little terminologies that can lead to a lawsuit, and all the times they don't, or running a gambit. What good legal counsel can do, or what a little bit of forewarning can do, is it can allow you to assess those risks. There's always going to be risks in business, employment, anywhere else. It's all structures made by people, right? So you're not, and so there's always going to be some issues and risk. What we can help you do when you look at these things, or what any lawyer can help you do, okay, is understand what risks you are taking. And even in high-end businesses, business owners who've been doing it for a long time, times change, businesses shift, and so being able to go in and understand exactly where your risks are. Like when you drive a car, you're going to drive your car. You need to drive your car. You can be as careful as you want to be, use all your blinkers, everything else, and there's still risk. Even though you do it every single day and you're totally fine and nobody would tell you not to drive a car. You understand the risk of other drivers, motor vehicle accidents, flat tires, engine problems. You understand these things instinctively. You may not know how to fix them yourself, but you do understand them. And so that's, again, when you're getting into any kind of contract or business relationship, understanding kind of the lay of the land. And that's all we're really trying to tell you to do. Does
Being
that
a business owner can be very rewarding and very fun, and especially if you're doing something you like. So
Race car driving.
We're not trying to scare you off
Yeah,
from
no.
operating a business at all. So, but there are always risks. No risk, no reward.
Exactly right.
Well, we've touched base with the business owners. Let's touch base a little bit with the people who are on the signing end of the NDA. Let's say if they are working at a company, they signed the NDA, but they wish to end their relationship or transition out of the company. What are some of the things to look out for or to prepare for to transition out of a company where NDA is signed?
First off, make sure that you have reviewed it well before you sign it. I'm sorry, I know you said at the end of it, but seriously, do not sign these things in a rush. But on the back end is understand what you're allowed to do or not do before you leave. And again, it's knowledge. It's being able to understand where your risks are. What are you absolutely not allowed to do under the agreement? What is questionable? And what are you allowed to do? So that you can plan. Ben, you know better than I do.
You know, we were going to touch on is intellectual property, and you know, anything that's created when you're an employee or an independent contractor. Normally, the company is going to protect that as their work product because you were being paid by them to create it. So who has the rights to that? And that's what Chris was talking about. You need to understand that, and you need to know when you depart, if you depart from this company, what your rights are. Was it a work product that you created for the company, or was it something that you did on your own and just brought it back to them and said, hey, I created this, do you want to use it? I don't recommend that until you get some legal advice on that end of it.
Yeah.
But the point is that, you know, there's a lot of things that can be involved in these non-competes and these intellectual property rights of the employer versus the employee, the NDAs. There's just a lot of pitfalls. They're necessary in our world today, very necessary. And you're going to see them more and more often than in the past because of the litigious society we live in today. But
thank goodness.
Yeah, it's sometimes good for the attorneys, I'll say that. But those are just things you really need to look at.
Yeah, and I know we need to get to some questions, but along those same things is that a lot of times, though, a little bit of knowledge can actually prevent you from having to leave a company. If you understand that you have some leverage or whatever your reason you're leaving is, and you go to them and say, look, I understand, yes, I can't do this, but this knowledge and skill base that I have, I'm going to be able to use elsewhere. It can actually open up some interesting negotiation or renegotiation or really nice severance packages if you have a little bit of extra understanding. It really can. More money for you.
Another reason to come see an attorney.
Mm-hmm. Money.
All right, well, let's go ahead and dive into those questions here. So the first one is, can my employer stop me from working for a competitor after I leave?
Maybe. Depends on what you signed.
Did you sign an NDA?
You signed that or a non-compete. If you're going directly into a business that's going to be competing, again, yeah. So it all depends on that. Now, if you're working at a fast food restaurant and leave to go to a different name brand fast food restaurant, I doubt that's going to apply. But the point is maybe you just have to know what you're signing when you're signing it. And look, when you go give your notice to a company, if you are leaving, that is the wrong time to sign any document that they put in front of you. It's too late in our eyes. I mean, just don't do it. You have the right to quit, and if they didn't have you sign it beforehand, before you started your employment with it, don't worry about it.
Yep, and also be very aware that, you know, if you sign it not as part of your onboarding package, so if you're an independent contractor and switch to an employee, the one you signed as an independent contractor may not apply to your employment. Yeah, that's a relatively new little loophole, but don't count on loopholes for your entire case strategy, okay? Don't do it. It's not TV. Well, I mean, this is TV, but your life is not TV.
Right.
Well, on a little bit of the more professional side, if you are working with someone, this is a question. This person has built relationships with their clients. Can they take their clients with them if they transition to a new company?
Oh, that's a big if.
Yeah, that's a yes and no answer. It just depends. Now, customers have the choice whether they leave a company or not. If you're not soliciting those customers, and they make the choice to follow you where you go, that could be fine. But again, I don't have any documents in front of me to review that will tell me whether you agreed to any kind of scope or limitation to that today. So it's all going to boil down to that, and again, what a court would interpret as reasonable under the circumstances of the agreement.
Yeah, the difference between non-compete versus non-solicitation.
Right.
And it's really going to depend on the language in there. Because again, you may not even be allowed to service that client if they do make the choice by your agreement. And so, yeah, you definitely have to be careful, especially in professions where someone may transfer, where clients really may follow somebody around. And so be very careful.
All right, well, Bennett, this one I'm going to throw your way because you want to touch base on this earlier. Who owns work I created while working at a company?
Yes.
Yeah, that's what I was thinking. That's exactly what I was thinking. Yes.
Again, that's going to depend on, whether you use their facilities, whether you created something in your garage and said, I want to use this at work now to make my life easier, and what kind of, again, employment agreements or non-NDAs or non-competes or any of that was signed. So there's a lot to unpack there, but generally speaking, if you're an employee and you're paid to do a certain job and you come up with a system or process that company uses at work, it's theirs. So that's just a generally speaking on that one. So be careful if you have this bright idea and want to come up with a new invention or something, and just be very careful how you do it because it might not be yours.
So don't create new inventions on your bathroom breaks while you're working.
No.
Yeah. Don't do it, man. Like it all comes down to what did you use, whose was it, what information, what facility, what time, what agreements you have in place. That is, again, you're creating ambiguity when you cross the streams. So it's a big area of law.
Well, guys, I'm sure we could probably talk about this all day. This is what you love doing. But please send us questions into us. So legalhelp@jmmtlawfirm.com. We'll be happy to answer them on air. Contact us directly if you need help. 256-533-5770. Otherwise, we'll see you next week to talk about more law with you.
And quickly, if you have any suggested topics, let us know.